morning, Chattanooga. This is Trevor Atchley.
I'm Clay Whitaker, co-host.
We're here for our weekly show called LegalBytes. Thanks, good to see you here today.
Thanks, Trevor. Back from the land of the sick and infirm.
Yeah, for those of our listening audience who weren't aware, which is probably most of you, Clay has been out sick with some flu-like symptoms. Glad to have you back.
I'm glad to be back. Glad not to pollute the local fine environs of Chattanooga with my illness.
Well, I certainly appreciate you being well while we're in the small booth together. I'm glad you're not still contagious. So it's good to see you here. Did you have a good holiday? Good 4th of July?
It was good. I felt very patriotic. I wore my red, white, and blue, covered myself with stars, and did all those things you're supposed to do on the 4th of July.
Well, good. We had a good time too. I have a couple of young children, and they really enjoyed the fireworks, and so we had a good holiday.
I see you got all your fingers, so you didn't blow any of them off.
That's correct. We watched fireworks. We didn't actually use any ourselves. They're a little too young for that, but yes, I still have all my digits.
Good.
So we're here today, and I think we talked about trying to cover 2 topics today. LegalBytes, of course, as we know, it's sort of to connote that we're going to give our listening audience a small bit of information regarding legal issues. And today we're going to talk about the first half of the show, an estate planning instrument known as a trust. And then in the second half of the show, talk about some land use regulations specifically related to Chattanooga's recent zoning changes regarding Airbnb.
That sounds like a good bite to take today, Trevor.
Yeah,
I want to talk to you about those trusts, though. That's something that you do a little bit in your business. Is that correct?
We do. Yeah, we do a fair amount of estate planning, and trust is one tool people can use as far as a wealth transfer mechanism for how they want their property to pass, generally speaking, upon their death.
I know we've talked a lot on various topics on LegalBytes, one of them being the topic of estate planning. So this is one of the sort of subsets of estate planning. It's a specific device that the law allows. Is that right?
That's correct. And it's sort of in your, I guess when you look at estate planning, you could say you have a toolbox, and a trust is one of the tools in your toolbox there for your ultimate objective as an attorney advising or counseling a client on estate planning matters is to counsel them and advise them. Ultimately, though, your objective is to ask them, how do you want your property to pass upon your death? Whom do you want to benefit with your property upon your death? Do you want to impose any restrictions on their use of that property? And so trust is one of the tools in the toolbox to accomplish the client's objectives.
I was going to ask you, the concept of the trust, is that always something that deals with the transfer of wealth or the protection of wealth at the time of death, or is that something that also deals with people who are still living?
That's a great question, Clay. A living trust, unlike a will, can be effective during your lifetime. And those are generally referred to sort of colloquially as a living trust. And what that really is a revocable trust, that the person who creates the trust is known either as a settlor or as a trustor. I prefer the term settlor. So the settlor will come talk to you about how they want their property to pass. And if it's a husband and wife, they want to come in together and have a joint estate plan. And you create what's called the trust instrument. And this is an agreement between the settlor and the trustee. And sometimes the settlor will serve as his own trustee. Sometimes the settlor will want somebody else to serve as trustee. But with a living trust, typically the settlor serves as trustee. And then you provide what the trustee has authority to do. And very often during the lifetime of the settlor is the primary beneficiary of the trust. And then the trust will provide provisions for the death of the settlor and how the property is to pass at that point.
Well, this is Clay Whitaker and Trevor Atchley. We're at Nooga Radio 92.7 FM. Any listeners that want to talk about the subject of trust in this half hour, it's 800-8949. Trevor and I'd be pleased to speak with you about this topic. And you can also call us at our office, McComb, Williams, Atchley, and Stanley, 756-6400. You need to talk more in depth about estate planning and particularly the development of a trust. So, Trevor, I was going to ask you, what do you, the set of circumstances, I mean, sometimes you see in popular culture, someone who is a ne'er-do-well, someone who's a wastrel, who has lots of money, and they have a lifestyle that might be even sort of biblical in the way that they use their wine and their women and things of this nature and live an extravagant lifestyle that's without morals. What kind of trust is available for a person like that?
Well, that's a great question, Clay. And typically you'll be looking at what's called a spendthrift trust there. And a spendthrift trust is one where the beneficiary has no right to demand or compel the trustee to make any distributions from the trust. And the spendthrift provision also protects assets of the trust from creditors of the beneficiary, where creditors of the beneficiary are prohibited from encroaching on the trust for the debts of the beneficiary.
Well, I know that in the past you've dealt with cases involved. I think we were talking on the way over here about conservatorships. It seems to me that in lieu of a conservatorship, sometimes maybe a spendthrift trust may be a way for families to address the bad character of some particular member who they want to look out for, make sure they're taken care of in the future. But, if they've got that sort of bad habit of using their money for things that ultimately will end up them being either on the public dole or someone who can't take care of themselves at all, that's the way to do it.
Well, that's an excellent point. I would also point out that when you're talking about conservatorships, a trust is a great tool for someone to use to plan while they're well, while they're confident, for circumstances which perhaps are foreseeable, that at some point in the future you're going to age. You're probably going to have some cognitive impairment, whether it's just a natural result of aging or whether it's from a disease or stroke. And setting up a trust provides a mechanism for you to authorize somebody in the trust instrument called a successor trustee, that upon the initial trustee's disability, the successor trustee comes in and then is able to exercise the authority under the trust instrument and continue to make sure we take care of the beneficiary, who during a lifetime is normally the settlor. But you're absolutely right. If clients come to see me and they say, we have a child who perhaps has special needs, and that may be a special needs trust, which is probably a topic for another day. It's for a particular type of trust. Or if they say we have an 18-year-old son and he's not ready to manage his own property yet, or we have a 30-year-old son and he's just never been able to get his act together. A trust in that circumstance, particularly the spendthrift trust, would be a great tool to use.
So what about a 53-year-old man that's in that same spot?
You're looking about 53 years old.
It sounds like all of us might need that sort of thing.
No, it is. The big disadvantage, or not disadvantage, probably the main consideration I would advise clients on in creating a spendthrift trust is there's going to be a lot of friction between the trustee of the spendthrift trust and the beneficiary, because in all likelihood, the beneficiary is going to be constantly asking the trustee for additional money, and the trustee will have a duty only to provide him an allowance, and then probably to pay third parties for the maintenance, care, and support of this beneficiary. And that's not going to go over very well with the beneficiary.
That's true, Trevor. We see that all the time in our practice, that sort of conflict between the duties that the attorney or the person who has a specific kind of duty might have and the people who are the beneficiaries of the trust. Well, what do we call that? So if we're talking about the special duties that a trustee may have or the attorney might even have in regards to the person who's the beneficiary of the trust.
That's an excellent question, and it's called a fiduciary duty. And a fiduciary is someone who exercises authority, whether it's making medical decisions or in this case controlling property interests of another individual. And the law imposes upon a fiduciary a heightened standard of care, where the fiduciary must always act in the best interest of the beneficiary as those interests are defined in the instrument. So we're talking about the spendthrift child, and the trustee's ultimate objective is to administer the trust pursuant to the terms and provisions of the trust instrument in the best interests of the beneficiary as those interests are defined in the trust instrument. So here you're thinking, well, how can the trustee act in the beneficiary's best interest if he's not allowed to make distributions to him anytime the beneficiary wants it? Well, that's entirely the reason you created the trust, was to essentially to protect the beneficiary from his own perhaps impulses or bad spending habits.
Well, this is Clay Whitaker. I'm here with Trevor Ashley. We're talking about trust today. We've been talking about specifically the topic of spendthrift trust. We're at Nooga Radio, 92.7 FM, 800-8949. If you have any questions about trust, please call us. We'd love to talk with you about that. You can also call us at our office at 756-6400. Trevor, I was going to ask you, a lot of times you'll hear in popular culture too, we were talking about the way these things appear in popular culture. Maybe some eccentric old aunt, old relative might have a trust that I want you to take care of my little dog Fifi, and you have to buy her certain kind of dog food and give her Grey Poupon every day. And that's, if you do that, then I'm going to make sure you get a certain benefit as a result of those actions in my trust. Is there anything in the law that says that you can't have strange or unusual terms of your trust?
No, there's not. And Tennessee actually has a specific code provision permitting trust for the benefit of animals and pets. At common law, before we had the code regulating trusts, the courts looked at that type of instrument, providing for the care and benefit of an animal as sort of a power of appointment, which is similar to a trust in a way, but basically the person who holds the power has to exercise the authority, and then it's not nearly the enforceability is not nearly as strong as with the trust. So now we have a specific statutory provision which allows creation of trust for the benefit of pets, and the question always arises: well, who's going to keep an eye on the trustee and make sure he's doing what he's supposed to be doing? So in that type of circumstance, when you're planning for that, depending upon how long you expect the animal to live, for example, a great example is, people don't know this, parrots live to be 100 years old or something. And so if you're planning for the care of this animal, which is going to live a long time, you might need to appoint some type of trust advisor who would be able to audit the books of the trustee and make sure everything's being done correctly. A lot of times you rely on the beneficiary to do that. But of course, the beneficiary here is a pet, and the pet's not going to be able to speak for itself.
Well, those are very interesting topics. What about the idea of this sort of thing we were talking about, specific trust for specific purposes? What if that purpose disappears? Like if you were supposed to buy Little Friskies for Fifi the poodle and feed her, but Little Friskies goes out of business and you can't get Little Friskies anymore, how do you fulfill the purpose of the trust?
That's an excellent question. So we're assuming the animal's still alive.
Animal's still alive. We got off on animal trust. It doesn't have to be an animal trust. It could be any other kind of trust. But tell us about, I guess, is that what we call the frustration of purpose?
Well, it can be. Now, there probably would not invalidate the trust or require it to cease, because you could theoretically, I would think, find an alternative food that perhaps is not the exact brand mentioned in the trust instrument. But if the trust instrument itself does not provide the trustee with discretion to make an election of an alternative source or an alternative food in that case, then the trustee would have to petition the court for instructions and present the trust instrument to the judge and say, Your Honor, here's what this trust provides. Here's what's happened. This food is no longer available. Do I need to just terminate the trust and distribute the money out, or are we going to find an alternative food to use in order to? Your ultimate objective always in those cases is to do what it was in the settlor's intent. So we're going to assume his intent was to take care of this animal, and the designation of food was probably the pet's. We'll say it was his favorite prerogative. But ultimately, the settlor's intent was to provide care for the animal. So I would think the judge in that case would say, we're going to use an alternative food source.
Well, and so I was going to also go along with this. Many times people in trust, we were talking about the way that they're set up. What if they said something that was illegal? Like, it required that the beneficiary, in order to receive the purpose of the trust, engaged in gambling or prostitution or the use of illegal drugs or something strange like that. Is that something that the law allows?
No. Well, that would not be enforceable. Now, on the other side of that, sometimes trusts are used to encourage the beneficiary to act in conformity with good behavior. So,
tell us about that then.
For example, if you have a beneficiary who has a gambling habit, and obviously this is going to be someone you'd have a spendthrift trust, but it may be that the settlor wants to encourage the beneficiary to go into some sort of rehab treatment center, and then there's probably a 12-step program available for people with gambling addiction. And to do those things. So the trust may provide incentives for the beneficiary to do that, and then upon completion of those programs, may provide for distributions directly to that beneficiary. So although the trust couldn't compel them to engage in illegal activity, the trust could be used as a mechanism to provide incentive for them to abstain from engaging in that type of illegal activity.
Well, good behavior and stuff is something that comes up in regards to people's responsibilities. And a lot of times I see in my practice that people will want to provide for the care and benefit of their children, particularly minor children. So how does someone, for instance, if they're concerned, that they may become incapacitated during their life and they want another relative to be involved in the care and custody of their children, how would you set up a trust, make sure your kids are taken care of if something bad happened to you?
Great question. So this is going to be the living trust. It's going to be a revocable trust that the parents, who would be the settlors here, are going to create. And they're going to provide for, they're probably going to name themselves to serve initially as trustee. And then the settlors will ultimately be the primary beneficiaries. They're then going to provide that upon their death or disability, a successor trustee named in the instrument will have authority to come in and take control over the trust. And the trust instrument would provide that upon that incident happening, the trustee would have discretion first, obviously, to take care of the settlor. And then upon their death, or if necessary during their disability, also to provide support, maintenance, care, expenses for the benefit of the beneficiary, support, maintenance, education, etc. And so then the successor trustee would have authority essentially to expend assets of the trust for the benefit of this minor child.
Well, Trevor, when those things happen, do you have to have a lump sum of money to start a trust, or can you start a trust and then continue to put sums in it?
That's a great question. When you create a trust, you do have to fund it, but it doesn't have to be an extravagant amount of money. It could be just a nominal amount of money, like a $10 vesting into the trust. It could be $100. Very often what people do is they will transfer all their assets into the living trust, into the name of the trustee. This would include, real property, bank accounts, stocks and bonds. And there's no adverse tax consequences for this, because with a revocable trust, because the settlor retains exclusive use and authority over the assets, but through the power of revocation, the IRS looks at it as using the same tax ID number as the settlor. So it's just essentially, for tax purposes, still the settlor's property, but we're providing a transfer of decision-making authority in the capacity to a successor trustee, and ultimately a wealth transfer mechanism for upon their death. So you can transfer assets in over time, but that can be a complication later if you don't transfer all the assets into the trust. The trust is only going to be effective over assets which are titled in the name of the trust. So if the client wants to sort of, add or trickle in additions to the trust, the problem could be if they don't get everything in before they're disabled or before their death, then you run into a problem where you're having to figure out how do we get the rest of these assets transferred into the trust.
Well, a lot of folks, and I think I'm probably one included, always have had the idea that trusts are for a certain socioeconomic class, so they're for the wealthy. But that's not really true, is it?
No, it's not. And this is a great point. You can actually create a trust in a will. It's called a testamentary trust. It's not effective until your death, and then the will provides that all of your property passes to the trust. So people with minor children who don't think they need to go through the exercise of creating a living trust or transferring all their assets can use the testamentary trust. I guess that raises the question, well, why wouldn't you always just use a testamentary trust? Well, some people don't prefer all their affairs to be private. And the big disadvantage to a testamentary trust is you have to probate the will, which is public record. If you use a living trust and transfer all the assets into the trust, then it's a private document, not a public record. So there's a certain amount of privacy protection there for the settlor. And trust probably historically have been for folks, living trust particularly, who have the means to do this, but it's something that everyone should consider doing if they have concerns about privacy. One additional big benefit to a living trust, which is not available in wills, is you're familiar with inter pares clauses?
Yes, I am.
No contest provisions.
Yep.
So it's a provision in the instrument that provides that if the beneficiary challenges the document, then he or she forfeits his or her interest in the instrument. Well, those have been used for a long time to scare off contests to a will. And Tennessee courts have always looked at that as presumptively unenforceable. But if a beneficiary does challenge the instrument, and the challenge is not in good faith based upon reasonable cause, probable cause, then it's enforceable. Well, the trust code reverses that the case of trusts. So now inter aram clauses in trust are presumptively enforceable. So if you have a client who's wanting to not treat children equally, or is wanting to disinherit a child, or is doing anything that they think is going to bring a challenge to the instrument, and you want to include the inter aram clause in order to essentially inter aram any terror to the person challenging it, so you hope to scare them off from bringing the challenge, then the trust is far preferable, because you're much more likely to be able to enforce the inter aram provision in a trust than you would be able to enforce the inter aram provision in the last will and testament.
Well, Trevor, this has been a very interesting first half. We've discussed all these issues related to trust. We're here at Nooga Radio, 92.7 FM. This is Clay Whitaker and Trevor Ashley talking to you about trust. We're from the law firm of McCoon, Williams, Ashley, and Stanley, 756-6400. Call us if you have any questions. We'd be pleased to speak with you about those issues, particularly as they relate to trust, but any legal issues we can certainly talk about today. Trevor, it's a great topic on the issue of trust. Certainly, as we've talked about this topic, it reflected in my mind. We just passed the 4th of July. We've received a great trust from our country. It's even on our coinage that in God we trust. There's all these ideas that we have received something of value that we have a responsibility to take care of.
That's absolutely correct. I guess ultimately that's probably if you had to sort of put it into the vernacular, the benefit of trustee is that the trustee is receiving title to property, not for his benefit, but for the benefit of the beneficiary.
So we also are in that same spot. Looks like we're coming to the close of the hour, or the half hour. So what we're going to do the second half, as you've already announced, we're going to talk a little bit about zoning regulations, and particularly this latest issue of some concern for Chattanooga, the Airbnb zoning, and discuss that. That ought to be a pretty good topic.
I think it will be. And one thing at the beginning of the next half hour, I kind of want to get your take on is a lot of people may not realize that zoning is a legislative way of regulating use of land. But at common law, we had things called restrictive covenants, where someone who subdivided his property or partitioned his property could impose restrictions on the use of the parcels that he partitioned off and sold. And so I'd like to get your take sort of on those land use restrictions. Yeah, regulation, that's the correct term. Restriction is the better term. Thank you. And sort of how that carries over then to our legislative efforts.
Sounds great. Sounds like it'll be a good topic. For all those people who like hearing these topics on LegalBytes, please give us a call. We'd love to hear any questions or concerns you have, any topics you'd like to have for future shows. We'd love to know about it. Please give us a call. We're here at 800-8949. Trevor Ashley, Clay Whitaker for the law firm of McCoon, Williams, Ashley, and Stanley. Nooga Radio, 92.7.
That's right. Please do give us a call. We'll be happy to answer any of your questions. We have just a few seconds here before the end of the half hour. Very interested in hearing our topic on land use restrictions, regulations. It's something
your blood boiling
that I think we covered on the station. Interested to have our conversation. We'll see you on the next half hour.
Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM. 3, 2, 1. Chattanooga Radio, AM 1240 and 92.7 FM's news. Now,
the whole corpse was discovered in Etowah on the 4th of July. The TBI has been called in to investigate. They say the body belonged to a as-yet unidentified woman, and she'll be sent to the medical examiner's office for an autopsy. Current Chattanooga Police Chief Fred Fletcher's tenure at the Chattanooga Police Department seems like it's going to end with a whimper rather than a bang. He's spending his last days on the job with personal leave time. Deputy Chief Roddy is one of the internal applicants, and he's applied to replace Chief Fletcher. He's the one who's in charge right now while Fletcher is on leave. Chief Fletcher officially off the job on Thursday. 3 kayakers, 2 women, woman and one man in Polk County got into a bit of trouble on the 4th. Their boats got stuck on an underwater tree, and they were stuck in the middle of the river. Rescue crews had to come out to get them. They're all okay. This was on the Ocoee River. Hamilton County Clerk Bill Knowles announced Tennessee.
White scattered showers and storms will pop back up through your afternoon and evening. Otherwise, very warm and humid, highs upper 80s tonight. Any showers diminishing after midnight.
Traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect very warm and humid weather out there for the afternoon, but only isolated showers and thunder showers possible. Highs into the mid-80s tonight, becoming partly cloudy, lows near 70. Hot, humid, upper 80s on Wednesday with isolated afternoon showers and storms more likely again Thursday. Check out Office Depot and Office Max. While you're taking care of business, Office Depot and Office Max are taking care of you with all work pro chairs and Magellan furniture on sale through the 4th of July. And I'm Storm 12 Chief Meteorologist Patrick Moore on Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader, Nooga Radio, AM 1240 and 92.7 FM.
McCune Williams and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances: business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza, and in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson, or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also, try the cheesy bread, wings, chicken, or bread with bacon, antipasta or Greek salad. Jet's Pizza and Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. JetsPizza.com. That's JetsPizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Hi, this is Nadia behind the green door. You've had ice cream and you've had shaved ice, but have you had snow cream? It is amazing. It's light, airy, fruity snowflakes melting on your tongue. You need to come and see us. Highway 58, green door next to Hardee's.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader, Nooga Radio, AM 1240 and 92.7 FM.
Hello, and welcome back to the second half hour of Legal Bites. I'm Trevor Ashley, and here with Clay Whitaker. And in the first half, we talked about trusts, particularly revocable trusts or living trusts. And in the second half hour, we're going to talk about zoning, land use restrictions, land use regulations, specifically related to this Airbnb. And Clay, it's good to see you here.
Thank you, Trevor. Good to be back.
And just so our listening audience knows, you live in an area of town where there are some bed and breakfasts and some single-family residential properties and some multiple-family residential properties. Isn't that correct?
That's right. I do live in an area in town that has a special zoning categorization, and it is one that would have an overlay of a federal statutory exceptions. It's a historic zone, so in that area, it has a lot of mixed uses. So one of the things when we start talking about zoning is there's a considerable amount of terminology, and that terminology helps you to understand what the legislation is and how it operates and how you can use your land.
So, okay, so we're talking about land restrictions and how a property owner uses his own property. And I mentioned to you before our break that I guess in common law there was a system of we would call restrictive covenants, and that would be where a common grantor or a common owner partitioned his property and then recorded restrictions in the Register of Deeds office that ran with the land that would say, you know, you can only build single-family residences on this property or something to that effect. And is it your understanding, or I guess it'd be my understanding, that zoning is sort of a legislative outgrowth of that type of land use regulation or restriction?
Well, I think it is, and I think it is also sort of the early 20th century, late 19th century historical movement. If you'll recall, the history of zoning had to do with improving the public welfare, the health and safety of the persons who lived in cities. So this is not an activity that resulted from rural land use. And so typically when you talk about restrictive covenants, you're talking about individual pieces of land, and that land either it has to do with your relationship to other pieces of property near you, and it has to do with the area where that property was. Well, in the way that things are today, in the state of Tennessee, certainly other states are the same way, we have what's called enabling legislation, and that legislation allows for legislative bodies, in particular municipalities, to decide to enact zoning. So this is not a statewide zoning. We don't have a statewide zoning. You have local zoning, and it deals with local problems, and that's really the issue. So when you talk about the history of zoning, for instance, I think New York City is the typical classic example of where zoning became popular, and it related to people building houses and not having, when they were building them in the city, and not having proper sanitation. And so you're discharging your waste on your neighbor, you're creating disease, you're causing vermin to live around, you know, where you've got mice and rats and other things, and you're cutting off the air and you're cutting off the sunshine to your neighbors by building tall buildings and putting them in the deep dark hole of your shadow, as it were. So that's where zoning came from. And so today in Tennessee, we have our own enabling statute that our legislature has decided and allowed to be used. And it came about in the early part of the last century. It's TCA 13-7-201 through 203. It's an enabling legislation that allows our local municipalities to decide that we want to make up definitions and a system that allows for due process to occur in the restriction of land use.
And so, I mean, I guess my point in talking about the restrictive covenants is this wasn't something that the legislature, through the enabling legislation, and then the municipalities, through acting pursuant to their authority under the
This is a coordinated monthly test of the broadcast stations in your area. Equipment that can quickly warn you during emergencies is being tested. If this has been an actual emergency, official messages will follow the alert tone. This concludes this test of the emergency alert system.
Okay, welcome back.
Well, that was our local broadcasters making sure we have an emergency action message and our system's operating properly. So those of you who care about that sort of thing, we are now back on the air and we have been cleared. So we were talking a little bit about zoning and about land use and about the enabling statute. And you had a question, Trevor.
That's right. My question was, so the legislature and then the municipalities, through their authority in this enabling statute, they didn't just invent this system out of thin air. I think it was something that had been in place through private action before it became enabled through the legislature to do through the city municipalities.
I think that's a fair statement. And I think the other sort of genesis of this, you agree with me that it's primarily related to commercial activity. So, for instance, I think there are a number of national associations and standards that were developed as a result of people being associated with their neighborhoods or their dwellings being associated nearby in proximity to commercial activities such as slaughterhouses. That was a very classic example of the requirement for zoning. And of course, in Chattanooga, we have that same sort of thing. We have the chicken plant.
No, that's an excellent point. I agree with you. And of course, there's other remedies, perhaps, to abate a nuisance if that was something that noxious odors or unpleasant odors are coming to your property. But I 100% agree with you on that. And people often ask, well, I wonder why the city allowed a chicken plant to be built downtown. Of course, when it was constructed, there probably weren't always residences around it.
I think that's true, Trevor. One of the things that we have this delicate balance, when we have the enabling statutes, you have economic growth, people engage in economic activities, and they invest their capital in it. Then you have the effects of that particular business, which may be, in some instances, might be very problematic for their neighbors. If there are noxious fumes or noises or those sorts of things for their neighbors, as that sort of thing becomes apparent and it becomes the trend at least to regulate that activity, then you have what's called a non-conforming use, or we might say it's grandfathered in. It's a use that now would not be tolerated in a particular area, but at the time it was appropriate because that's where the land was available. That's where the city had encouraged economic development and growth. And the fact that people now moved in next door to the chicken plant or have moved into whether it's concrete plant or whatever the other kinds of things that might be loud or noisy or not be suitable for residential, that doesn't matter. Now you have a set of circumstances that allows for the government to control that.
We have a call coming in.
All right.
Hello, caller. You're on the air.
I love you guys, but I haven't been in a time like zoning. And I think we're on the slippery slope here, and I'm going to throw this out to you guys think. As in Hell versus Hinkle, the Supreme Court ruled there's a clear distinction between a corporation and an individual that says a corporation is granted privileges, it must submit to books and records, an individual must stand upon constitutional rights, which means that must extend to their home. And I see one can argue health, safety, and welfare. Putting a gas pump next to a single-family dwelling. All right, that kind of makes sense. You argue police powers. But when it comes to the city of Chattanooga, don't believe they can tell me in my private residence that I can't assemble because there's a right to freedom of assembly. That's what it is, and that's what should be argued. I can invite people into my home, whether it's one person or 20, to assemble. And at the end of that assembly, they give me money or trade with me for the use of my home. And they think that could be regulated. They're nuts.
Well,
they have to violate it. At least 3 rights in the Bill of Rights to do that.
Well,
First, the fourth, and the fifth.
That's an excellent question, or an excellent point regarding the right to assembly. I would point out that in other, places of assembly, public parks, things of that nature, the U.S. Supreme Court has interpreted the Constitution to permit municipalities to require permits for that type of assembly.
Well, they're not public parks; they're government parks. There's a difference, and the court never has to interpret the Constitution. If it did, it'd be void for vagueness. Well, the court gives an opinion as to a particular statute and how it applies to the Constitution. I hate when attorneys say it has to be interpreted. There's no ambiguity in the Constitution. But it's not government land. I mean, it's not public land, it's government land. They're not public buildings, they're government buildings. There's a clear distinction. My home is my castle. I'm going to buy a house in Chattanooga now, and I'm going to rent it out. And I'm going to challenge this to the Supreme Court myself. And I'm going to beat Chattanooga. Watch.
The caller, we certainly appreciate the enthusiasm that you have for our Constitution. All lawyers appreciate that sort of enthusiasm, and we certainly wish you the best. So appreciate your call. Thank you for the topic, for weighing in on this topic. It's certainly one that's important for the citizens of Chattanooga. Any other callers, please call 800-8949. We'd love to hear from you.
I think that's an interesting concept there, though, to assert a challenge to this zoning regulation based upon a right to assembly.
But you know, Trevor, that's been challenged, and legally it's been challenged. So, you know, one of the things about zoning is it is really one of the most local examples of the government and the citizenry coming together and having their own interaction to form their own laws. Now, whether we agree with the way it turns out or not, it's not the point. The point is it participatory, is it representative? And I think it is in some regards. Now, one of the questions I've got is when it comes about what the caller was talking about, the right to assembly. It's happened in house churches. That's a good example. So the problem has been, let's say that you've got 30 people that come to your house on a regular basis, Wednesday and Sunday, for a house church. And by doing so, they take up parking on the streets and byways. They cause an obstruction in the streets and in the byways. The neighbors can't park on the street anymore or are being obstructed in their use of the street where they live. And there's noise and other distractions that are associated with that sort of regular gathering. It's been held that that's an appropriate regulation by the municipality to make sure that people don't overuse or to cause that sort of burden on their neighbors.
I think it's a great analogy, and that I think would be applicable to that type of argument against the Airbnb ordinance. But so we go back to what we were talking about before with the chicken plant. And we're talking about how today they would not be allowed to construct that chicken plant where it is. It would be a non-conforming use. Now, when they enact this new zoning for like the R1 or the form-based zoning to allow mixed use of these properties, can the city come in and shut down the chicken plant?
Well, they have in the past. I think there have been those sort of attempts to do that. But typically the answer is no. And I think the reason is, and certainly under Tennessee's Constitution and under the federal Constitution, that would be an unconstitutional taking. You know, you have a right to have your property and to have due process and to use that property, just like the caller was talking about. There are certain restrictions on that use, and it can be as a result of overburdening your neighbors, or in this case, because you got the overlay of the enabling statute violating particular municipal statutory code that relates to zoning. However, you can't keep a person who's invested capital in their property from being able to use it for that purpose, certainly without due process. You know, there is a standard of the law, and the law says you can't act in an arbitrary, capricious manner.
So let's carry this forward now. So we have, with the chicken plant, we have what had been a lawful use, which now, because circumstances have changed in the neighborhood and there's been rezoning, would now constitute a non-conforming use, but your terminology, I think it was grandfathered in. Now with the Airbnb, so these are single-family residences zoned, I think, R1, where we're now, people have been using these single-family residences essentially for some type of commercial purpose, allow people to come in and stay, not what we traditionally define as a single-family use of that property. How is there any interlay there? Is there a grandfather type application where you have been using it with a non-conforming use, and now we have the zoning regulation requiring the permitting?
Well, so here I think is the issue. And for those people who may be subject to this is the problem. So one of the things you talked about was we were using the analogy of the chicken plant. You know, you've got two separate issues. One of them is prohibition. So can the government prohibit a particular type of use? Okay, let's say that the chicken plant was causing disease. We knew that it was causing avian flu. Can the city come in and shut down the chicken plant because we know that it constantly causes avian flu? You know, theoretically, I think under the health code, it might be able to severely restrict or limit the use of that plant in that area if it was causing an epidemic of avian flu. I think that's reasonable. But all of these restrictions have to be reasonable. So a complete prohibition is probably not. One of the things I think that the city is wrestling with is what kind of restrictions are necessary to allow the use, but to protect the neighborhoods or the areas where this ordinary use might not have been one that was contemplated before the development of the Airbnb system.
Now, one one criticism I've heard, you mentioned this arbitrary and capricious standard. So this is a twofold question. First, can you explain to us what arbitrary and capricious standard is? And then two, one complaint about this Airbnb zoning ordinance is that the city essentially drew what has been described as artificial lines, where there's an overlay from Lookout Valley basically to the ridge. Everything west of the ridge, Airbnb is allowed to, but you have to be permitted. And then east of the ridge, it would still constitute a non-conforming use in R1 zoning area. So explain to us arbitrary and capricious. And then two, does this, or what has been described as artificial line, constitute arbitrary and capricious?
Arbitrary and capricious just means that the decision-making process by the governmental entity. So when we're talking about the application of a zoning rule or regulation, typically what happens is you make an application, and this is all in context of the zoning regulation. So if you have a particular zone, it has a number of types of uses, and you want to make an application for a different type of use, or your property, you're trying to get it classified in a certain way, you typically have to make applications to the government to allow that use to occur. And if they make a decision and that decision comes back is a negative one, and you want to argue with them about it, what you want to examine is what are the reasons for the decision. Well, the problem with many decisions that have been made is that the entity that makes that choice does so based upon a lack of reason. So there has to be a governmental purpose, a governmental stated purpose, and it has to comply, and it has to have some reflection in the standards of the zoning code or ordinance. Otherwise, you can make the argument that the decision-making was arbitrary. That is, that it wasn't based upon the zoning code. It wasn't for a governmental purpose or reason. It didn't support that governmental reason. It was simply for they didn't like you. They didn't like the way that it looked, or it wasn't something that they thought would be appealing. Those aren't necessarily parts of the zoning code. It is something that the decision maker used that didn't have that basic reasonableness that you need to find in terms of the decision-making process.
So then looking at what have been defined as sort of artificial boundaries for this Airbnb overlay, which has the eastern, western boundary, north and south boundaries. So there's a section of the city where it's permissible use now. I guess to determine whether it would constitute an arbitrary and capricious zoning, you'd have to look at what, I guess, the city studied and what factors they considered in making this zoning area.
Well, and so we're talking about two separate things. Individual zoning. We got another caller. Trevor.
Hello, caller. You're on the air.
Hey, Clay and Trevor. Good commentary. Just a question. As between two neighbors on opposite sides of the street, how can the Airbnb zone not be arbitrary and capricious? You have a street, and the line for the district goes down the middle of that street. On one side is a man who is allowed to use his house for an Airbnb arrangement, and across the way is another man who can't. Both are in like position legally. Both are homeowners. They are indistinguishable one from the other. So how can that map at any point be legal and constitutional and avoid the hazard of being arbitrary and capricious when among wherever that line goes, it's an arbitrary distinction between neighbors all the way down that line.
Well, caller, here's something I think we need to discuss, and I was just getting ready to address this before your call, but the issue I think that needs to be distinguished, in any zoning scheme that we have, there are planners, and planners develop policy. Policy is based upon the needs of the community, and as a result of that, you can determine whether or not the policy might in some way deprive someone of due process, but it might not ordinarily be considered an arbitrary and capricious decision. That description or that terminology is used in individual zoning cases. That's our time, unfortunately, for today. We appreciate it. This is LegalBytes, 92.7 FM, Clay Whitaker and Trevor Atchley. 800-8949. We appreciate all the calls today. Thanks again.
We'll see you next time.